Good afternoon and welcome to the Appellate Division First Department's oral argument for Thursday, February 17, 2022. We will commence with the call of the calendar. I will announce the times that have been granted for argument, and there is no need to respond by counsel. People versus Llc Edwards. Appellant, you've been granted 5 and 1. Respondent, you've been granted 5 minutes. Fuentes versus Lindsay Park Housing. Appellant, you've been granted 5 and 1. Respondent, you've been granted 5 minutes. The case of L. Children is submitted. Dhcr versus Bellotti. Appellant is granted 5 and 1. Respondent, 5 minutes. Garcia versus New York City Office of Children is submitted. Lopez versus Shea. I see that Mr. McEnany has joined us in the 11th hour. Mr. McEnany, in the future, please sign on sooner than 1 minute before argument time. Okay, I see that you are here. You've been granted 5 and 1. Respondent, you've been granted 5 minutes. People versus Albert Cotto is granted 4 and 1 for the appellant, 4 minutes for the respondent. Shanghai Youngrun versus Kashi Gallery. Appellant is granted 6 and 2. Respondent is granted 5 minutes. C. Hillary versus Michael K. is submitted. 128 Histor Llc versus New York City Division of Housing. Appellant is granted 6 and 2. Respondent, public administrator, is granted 4. Respondent, New York State Division of Housing and Renewal, is granted 4. Berg versus Chelsea Hotel is submitted. Parker versus Trustees of Spence School. Appellant is granted 6 and 2. Respondent is granted 6. Wormwood Capital versus Melody is granted 4 and 1 for appellant, 4 for respondent. Pavich versus Pavich is submitted, and Gottwald versus Sebert is submitted. First case on the calendar, People versus Llc Edwards. Mr. Zeno, the floor is yours. You have 5 minutes, sir.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Llc Edwards. May it please the court. Most important witness in this case was Jose Morgan, who claimed that he saw Mr. Edwards shoot Christopher Chow and then yelled menacing threats at him. The extremely grainy surveillance video seems to suggest that Mr. Morgan was not in a position to see what he claimed, or at least he wasn't where he said he was standing. No one else witnessed the shooting or these alleged taunts after the shooting took place, which were critical to proving intent.
Mr. Zeno, are you suggesting that we should evaluate the witness's ability to see based on a grainy video surveillance system outside of this particular location?
Yes, I am, Your Honor. He described his location. He was asked to point out at one point in reference to a tree. There were only 2 trees in the area. He was asked to point out where he was standing in connection to the tree, and he wasn't there. The people try to claim that there was a blind spot in the surveillance video, but if you...
Counsel, Justice Rodriguez, what you're asking us to do, presumably, you made the same arguments to the jury, and obviously they decided the other way. Why should we disturb that?
Right. So that really gets to my second point, which was really the more important point that I wanted to argue, not the weight of the evidence point, and that was Mr. Morgan's emotional outburst. And I think that outburst tainted the jury's evaluation of Mr. Morgan's testimony.
Counsel, this is Justice Gonzalez. Was there any objection or any request for a curative instruction? Because my understanding is that this was unpreserved.
Your understanding is correct, Your Honor. It is unpreserved. I would point to the fact, in asking the court to consider it in the interest of justice, that this was a really contentious cross-examination. counsel was doing his job. He was calling the witness's attention to the video, calling the witness's attention to differences, changes from his grand jury testimony, and the witness became angry, basically at being called a liar, not in so many words, with appropriate impeachment. And in the heat of the moment, when this cross-examination was taking place, counsel decided not to call further attention to the outburst, not to paint, not to emphasize it to the jury. That renders it unpreserved. Can't contend otherwise, but it's an understandable decision under the circumstances.
Mr. Zeno, this is Judge Mazzarelli.
Yes.
I don't see this as such an outburst. I mean, and I don't see it as such a contentious cross-examination. I mean, to me, it's relatively mild. Yeah, the lawyer called him a liar, and he said, "You got a video? It's a different tree." I mean, I don't find this to be of the level that you describe it.
Well, it escalated to the point where the witness asked the lawyer if he had ever seen anyone die in front of him. And that was the ultimate issue that the jury was supposed to decide in the case.
Well, so he asked, I mean, the witness is not supposed to ask the lawyer questions, that's to be sure, but it is a traumatic experience that the man had. And I mean, I just don't find I don't find any error here.
I understand what you're saying, Judge. I hear you. I hear your side of it, but
not my side. I don't have a side here, Mr. Zeno.
No, I understand what I wasn't suggesting you had a side, Judge. I was suggesting I see where you're coming from with your interpretation of the error. I would just say that when the
wouldn't Mr. Zeno, would that not have been absolutely legitimate argument on summation? So that even if I were to agree with you that it was an outburst that perhaps the court should have sua sponte said something about, right? What the witness said is something that the prosecutor would have completely been entitled to argue in summation anyway. So what's the harm?
Well, the harm is that the prosecutor did argue it in summation. The prosecutor exploited what the witness had come back with.
But why not? I mean, my point is, it's a valid point. What you think about and what you are focused on in that kind of situation is going to be different than a non-threatening set of factual circumstances, right? If you see somebody being shot, I don't think there's any juror that would disagree that that's a traumatic event to witness that. So why is that error in light of that common sense observation?
Having the witness vouch for his own credibility by telling the jury that this was a shocking event, when the shocking event is the ultimate question in the case, whether or not he saw that shocking event was what he was being questioned about, his error. With my time remaining, I'd like to turn to the question of sentence, Judge Manzanetti.
Okay, I'm gonna give you a minute. Go ahead.
Okay. We're all aware of the problem of gun violence, particularly with young men in this city. But an 18-year sentence, nearly 3 times the minimum here, was inappropriate for this case. My client was the subject of a physical argument where his friend was dragged outside. Before this crime, he was 24 years old. He had, minimal involvement with the criminal justice system, no prior history of violence, and was given an 18-year sentence. An 18-year sentence does nothing different than a 10-year sentence, except keep my client locked away for another 8 years. It does not impact whether he's rehabilitated, whether he has an opportunity to change. 18 is just a number picked out of a hat. that really has no impact except locking my client away for almost, double what he should have been locked away for. 5 years is the minimum sentence. He reacted
And you think 5 years for taking life is an adequate sentence?
I started out by saying I think 10 years would have been an appropriate sentence, double that minimum. Manslaughter is, manslaughter has a range of from 5 to 25 years. So there are some manslaughters that only warrant a 5-year sentence. I'm not saying this is one of them, Your Honor. I'm saying that there is some enhancement about that, but almost quadruple for someone in my client's situation who reacted impulsively to he and his friends being attacked is just too much time.
Thank you. All right. Ms. Farrington, you have the floor. You have 5 minutes.
Good afternoon. Lori Farrington for the respondent, the people of the state of New York. As to the first point, the weight of the evidence, I will, unless your honors have any questions, just briefly state that the jury's inference that the defendant intended the natural and probable consequences of his acts, shooting at the victim, was a reasonable inference, and there's no reason for this court to overturn the jury's credibility determinations. As to the second point, Mr. Morgan's statement, he merely said, "You ever got a victim shot in front of you? That things stay in my head, even when I'm asleep, so I know what I said." That does not go to the defendant's guilt, and the jury, as instructed by the court, is entitled to consider a witness's memory of the events. And the defense in this case was not misidentification, was not that Mr. Morgan was mistaken. It was that he was lying about every single thing, that he was not there. Had the jury found that that argument was credible, it is unreasonable to believe that a mere statement of that things stay in my head would change everything. The jury found Morgan's testimony credible, and there was numerous reasonable bases for doing so.
Ms. Farrington, this is Justice Rodriguez. Can you address the excessive sentence claim?
Absolutely, Your Honor. Thank you. In terms of the sentence, the defendant shot a fleeing man in the back and killed him. Not only that, he attempted to take this gun into the club in the first place. When he was not allowed in the club, he hid that gun 2 doors down at One Stop Deli. During the fight, he purposely went and got the gun, chased everybody out, fought his way out as the victim tried to hold the door closed. When he finally got out.
The facts, counsel. The question is whether an 18-year sentence on a defendant with his background, and under the circumstances, this isn't he jumped out of nowhere and shot this guy for no reason. I'm not suggesting that he was entitled to shoot the victim, okay? So don't misunderstand what I'm saying. But there's no question that the victim was involved in an altercation with men that this defendant was with, and that they were beating up on, I believe it was his brother.
And there is also
right. So this isn't a crime that happens in a vacuum, right? So
Correct.
Is 18 years for someone with his status appropriate?
Yes. There was an altercation. The altercation had ended. He shot a fleeing man in the back. And the court states on the record that it took his age into account. It did not grant the people's request for the maximum. But the fact remains that this defendant, perhaps knowing there was going to be an altercation, brought a gun with him that evening. And when the altercation ended and he had the opportunity to run in the opposite direction, he turned and shot a fleeing man in the back. That absolutely warrants an 18-year sentence. And the court.
What was the last offer of the people before trial?
I'm not sure, Your Honor. I believe it was a plea to the manslaughter in the first degree, which was what he was convicted of. I do not recall the number of years. I believe it may have been 15, but I can't swear to that. I would have to look at the record.
Okay. All right. Any other questions? Thank you so much, Ms. Farrington.
Thank
Mr.
you.
Zeno, you have 1 minute.
I'll be short. I don't think I will ever agree with the prosecutors when they say that 18 years is an appropriate sentence for someone with no violent history, 24 years old, with a possible future ahead of them if they're not locked away for 18 years. There were a range of very serious sentences that could be imposed well short of 18 years. And I ask this court to exercise its independent discretion and reduce the sentence.
Thank you so much. Fuentes versus Lindsay Park Housing, counsel for Appellant. I am afraid I will mangle your last name, so I'm going to let you tell me how to pronounce it.
Good afternoon, Lisa Gokulsing for Lindsay Park Housing Corp.
I would have definitely messed that up, so I'm glad you said it instead of me. You may proceed, counsel. 5 minutes.
The lower court erred in reinstating the plaintiff's 200 and 241-6 claims. The plaintiff was doing what was really routine maintenance at Lindsay Park. Lindsay Park, when an apartment becomes vacant, the superintendent and his staff, his laborers, they come in and they do things like, switch out faucets or, switch out light bulbs.
Well, in this particular apartment, they had to lay new tiles. In fact, that's why we have an injured plaintiff, right?
That's right. So, and that's one of the things that they.
So it wasn't just painting, even though painting is one of the enumerated activities that's covered, right?
That's right. So, right. And then after the regular maintenance guys get finished with their work, the apartment needs to be painted. I'm sure that the court is aware that landlords in multiple dwellings must paint and repaint apartments every few years. And so that is our position, that this was routine maintenance. The Court of Appeals discusses— If
we don't agree with that assessment and think that this falls within the labor law, what other arguments do you have?
Okay. Obviously, my second argument is that any claim under 241-6 relies on a concomitant violation of an industrial code provision. And in this case, the plaintiff relies on two provisions, 23-1.7D and E. Those refer to slip and trip hazards. The way that the statute is written, it refers to snow, ice, debris. It refers to matters of that nature, tripping hazards, things that. But
it does have, counsel, it does have a catch-all phrase in the statute which says any foreign substance which may cause slippery footing shall be removed. So it's not limited to just snow, ice, water, and grease, right?
Yes. But if you look at the totality of those provisions, it really refers to items that should not be there. And in this case, the plaintiff is the only person who saw this plastic floor covering. No one else ever saw it.
Does anyone controvert that there was indeed plastic covering these tiles? I don't remember seeing any affidavit saying there was no plastic.
Well, either way, the plaintiff, we moved for summary judgment, and so we have to take the plaintiff at his word. So we absolutely did that. The plastic was there because the plaintiff said that it was there, and the plaintiff said that that was the cause of his fall. But the plaintiff, who is also the only witness, described the plastic in a particular way. He said that it was laid down in order to protect the new tile floor.
Counsel, excuse me 1 second. I just want to be clear. You moved for summary judgment.
Initially.
Correct. And then when the court granted re-argument, it reinstated the cause of action for a claim under 241-6 of the labor law. But
and 200.
And 200. My learned colleague already addressed the 200 issue, and you spoke on that. On this issue, am I mistaken? But the lower court did not implicate Industrial Code Section 23-1.7D as a David. It implicated only 23-1.7 E1 and E2. Am I correct?
That's correct.
So that is the only regulatory predicate, so to speak. When I say you have to have a linkage between 241.6 and an industrial code section, underpinning it on this very, and there's no cross appeal, am I correct? So so just bear with me. I just want to be clear here and precise. So your whole argument about whether, I'll be short, subsection D is implicated is not here, correct?
The issue is that the plaintiff and his counsel went back and forth between whether it was a slip or a trip and implicated both provisions. So yes, you're correct that the court only reinstated one, not both.
Right, and the issue of slip and trip, if I'm not mistaken, that those differences of those hazards and the distinctions as to whether subsection E is implicated because he slipped, arguably, was first raised now on appeal. You didn't make that distinction in moving for summary judgment below. Am I correct?
Oh, no, we absolutely did.
Oh, you did?
Yeah. Oh, we absolutely
Okay,
did.
so bear in mind, but
Yes.
then
Yeah,
isn't there, I stand corrected, but isn't there a precedent in this department that in dealing with subsection E, we don't get caught up with slip trip? It's really the overall efficacy of trying to protect for those hazards that they're really synonyms, so to speak.
Which is why I didn't make that argument and I didn't get caught up in between D and E and whether he slipped or tripped.
Fair enough.
In my reply brief, I actually argued that basically the plaintiff overlooked or sidestepped whether it was a slip or a trip. Right. And we didn't really even raise that issue. The issue that we raised is that because the plaintiff described it as a protective means of protecting the new tile work that was done, his testimony is more in line with several cases, a few out of this department, Dhcr versus 1 Bryant Park and Johnson versus 923 Fifth, where that work or that protective measure becomes integral to the work. Plaintiffs have slipped on plastic, they've slipped on masonite, but when that is deemed a protective measure, it's deemed part of the work. So it's not considered a slip hazard, a trip hazard, or a dangerous condition. That obviously flows into my second argument related to the Labor Law 200 claim. The lower court reinstated the 200 claim on the grounds that there was a dangerous condition on the premises. And that arguably my client created the condition because, of course, who else would have put the plastic down? My position is that, again, the plaintiff is the sole witness. And so he described what this condition was. He described why it was there. That is the only testimony. So we have to rely on his testimony. And if he describes it as a protective measure, then it's not a dangerous condition.
Well, he did, counsel, just to be clear, the record is very clear that he thought painting on top of plastic was dangerous to him. And the issue is, does the labor law concern itself with the danger to tiles or to surfaces or the danger to people? I'll let you think about that and respond to that on your time in rebuttal. We're out of time. Okay. Counsel for respondent, you have 5 minutes.
Good afternoon. I hope everybody can hear me. My computer froze up.
Yes, hello? I can hear you. We can hear you.
I apologize. My computer froze up right after the call, so I'm on my phone. Quickly, 241.6, painting is a protected activity. That's what the plaintiff was engaged in when his accident happened. Doesn't have to be incidental to any other work. Joblon, Court of Appeals, First Department has ruled on that also. As to the industrial code sections, I'm not sure which judge pointed it out, but it's correct that the court just reinstated 1.7E, the tripping one. Here we have an obstruction condition that caused the tripping that should have been removed. It's clear violation, specific violation. And finally, as to the plastic being integral to the work site, nobody ever stated that. Plaintiff never stated that. He said he had never seen it before, didn't know why it was there, complained about it. Defendants themselves said they had never seen it before either. So nobody knows why this plastic was there or what its purpose was. So it's, and as far as 200 goes, the only, and a notice of the dangerous condition, the only ones who did any work in the apartment prior to the plaintiff arriving was the defendants themselves, including installing the new flooring. When plaintiff arrived, the plastic was already down on the floor. Nobody else had access to the apartment. At least it's constructive notice, you know, as to that plastic being there. And if there are no questions, I'll rest on my brief.
Do you rely on any particular case law that would support that plastic on a floor in and of itself constitutes a dangerous condition?
Well, there's the Lois versus Flintlock First Department 2016 case. It wasn't plastic on the floor; it was a plastic tarp thrown over or in a passageway that the plaintiff tripped over. And in that case, the First Department found that it constituted a violation of both 1.7E, the tripping section, and 1.7D, the slipping section. And that was the whole case where I believe it was Justice Rodriguez had mentioned the differential between slip and trip. There really is no differential. The court said that's not dispositive on which section applies. And in that case, they reinstated the plaintiff's 241-6 claim.
Okay, thank you so much.
All right, thank you.
All right, counsel, you've got 1 minute on rebuttal.
Okay, so I just wanted to finish up on my second point on the 200 claim, is that the plaintiff was provided with cloth drop cloths and chose not to use them. Now, let's not forget that he's there and he's painting.
That's not the testimony of the plaintiff. The plaintiff said that he wanted to use wanted to use cloth drop cloths, and he was told to use the plastic. That it was there, and he had to use it.
No, that's not what he was told. He was not told to use the plastic. No one ever told him that, including his own employer.
I said that's what he testified to.
No, but that's not what he testified to, Your Honor. I just want to correct that part of the record. What the plaintiff said was that he complained to his own boss that the condition was slippery, and his boss said, "Hurry up and finish." That was the testimony. He had his own cloth drop cloths. He did not use them, and so my argument is that the lower court, when we originally moved for summary judgment on the 200 claim, we argued that it arose out of the means, methods, and materials of this work because the plaintiff had the opportunity to use his own cloth drop cloths, and he did not use that. He also recognized that it was slippery. He called his boss to say, hey, or actually he went back to the building and had lunch and told his boss at that point, hey, it's slippery, and he went on with his work. So our argument is that the condition that caused
Counsel,
the accident—
if I may, do you have an affidavit or anything from anybody who says that putting a cloth over a plastic covering is a safe condition?
No, because that's not what happened here.
No, you're saying that that the plaintiff could have placed a cloth
Over the plastic.
with the
Over the
plastic.
plastic. Yes. No, but I guess that because—
How would that have been safe is, I believe, what my colleague is getting at.
Right,
How
I
is
understand
that safe?
Right, I understand that, except that an expert is only supposed to testify as to facts and evidence.
So you're
and those were
positing
not—
this on your own, right? You're offering your opinion as to the safety of such a move on the plaintiff's part, putting
again,
cloth plastic over a floor.
Yes, our argument was that it was a means and methods case, and that he had an appropriate drop cloth, and he chose not to use that.
Counsel, wouldn't that really be an issue of comparative negligence for damages purposes and not necessarily defeat the 241 claim? Let's accept for purposes that we have an industrial code predicate subsection E to support it. The then you would be able to advance that at trial, that he had the ability to use the drop cloth and probably reduce damages, assuming,
Right.
do you hear that part?
I hear that part and I understand that part, but again, I go back to the plastic condition. The plastic drop cloth that he says is there was integral to the tile work that was on the floor, and it was there to protect it.
But it
Council,
wasn't his work, so I don't understand how that is at all relevant. The tile
Well-
work is done, and it seems to me like what was going on here is his boss was more concerned with not damaging the tile than his safety. And how does that feed into the spirit of what the labor law is supposed to protect?
I understand that the labor law is remedial and it must be broadly construed. I understand all of that. But counsel, in discussing the respondent's argument, he mentioned the case from the first department. And when the plastic drop cloth was laid in that particular case, this court noted that it was laid, according to the plaintiff's testimony, negligently. That's what caused him to trip on it. We don't have evidence of that here. The only evidence that we
Except
have
the
is
plaintiff's
own
testimony that he tripped on. Look, if there are pieces of plastic being thrown one over the other such that his feet become entangled in the plastic as he testified to, then it seems like there certainly is an issue of fact as to that. Anyway, I think we've exhausted the arguments. Thank you so much. And we will take your case under advisement. Have a good day.
Good afternoon.
Next case on our calendar, Dhcr versus Bellotti. Counsel for appellant, Mr. Polito.
Good afternoon. My name is,
5 minutes.
thank you. My name is Joseph Polito from David L. Putcher and Citron. I represent the appellants in this case. And simply, really, this case is nothing but disputed issues of fact, making summary judgment inappropriate, which is why the court erred in dismissing appellant's amended complaint and granting respondent's first counterclaim. To begin, I'd like to start with the first issue and where the court erred, which is respondents did not meet their burden on summary judgment. A prime example is that Bellotti did not complete the project within a reasonable time. And it's a reasonable time because the contract does not set a completion date. Mr. Bellotti met with Ms. Dhcr in 2012 in the Minimal USA showroom. And at that time, a week after, he was hired and he began to do the work. He started working in 2012. In December of 2012, he sent a schedule saying, this is what's been done, this is what's been ordered, and later in April and June finalized the completion date of December 2013, which included not only the delivery of the products, but the installation. That did not happen. Mr. Bellotti was terminated in February of 2015, not having completed the project. Respondents tried to say, well, there were no ceiling heights, so Mr. Bellotti couldn't have started. That wasn't an issue. In all of the emails in which he committed to a December 2013 completion date, he never raised that he needed ceiling heights. The respondents state, well, no work could have been done because the contract wasn't executed until 2014 by Mrs. Dhcr's agent. That, too, doesn't make any sense here since he was working from 2012 through 2013. So that is a clear question of fact that was not resolved by respondents. Another question of fact that was even raised by respondents themselves is this concept that work couldn't have been possibly done because there's a condition precedent in the contract. That also must fail because not only is it the contractual language not a condition precedent, but there's a question of fact then that he waived it by doing the work after. He never stopped doing work in 2014. There are plenty of emails in the record that show that he was continuing to do the work. He also received the full deposit by late 2013. So there is no prevention there in terms of him working, and that's waiver. If you were to agree that there was a condition precedent, there's waiver, and that in itself is a question of fact. Going more specific with regards to the court's dismissal of appellant's breach of contract, which is both the first and second cause of action. Quite simply, there's excuse me, the contract is ambiguous in the sense that what's required is custom-made furniture from Italy. On top of that contract, in bold, is Minimal USA from the seller Minimal. And as we assert, the expectation was to get those Minimal Cucine products, which was represented to Ms. Dhcr a year and a half before she even got the contract. And clearly respondents claim that Minimal Cucine was not guaranteed by the contract, but at the same token, neither was Canova, which is now apparently the actual company which name is nowhere on the contract, as well as the vendors that they actually use, such as Control Tempo. There was nothing in the contract that gave Bellotti some sort of carte blanche to just bring in whatever contractor he wanted.
Counsel, can you address the question of the fraud?
Sure.
Fraud claim versus the breach of contract claim?
So
and the defendant's lack of home improvement or other licenses. How does all of that play together?
Sure. So I'll address the fraud claim first. In essence, the lower court dismissed the appellant's fraud claim as being duplicative, which is not the case. At issue here were the misrepresentations made to Dhcr in May of 2012 while inside the Minimal USA showroom surrounded by Minimal Cucine products. Mr. Bellotti at that time, per Mrs. Dhcr's testimony as well as her affidavits, stated that Mr. Bellotti made these misrepresentations to her. Mr. Bellotti, at his own deposition, said he couldn't remember anything about the conversation. However, in his affidavit, he said that, Minimal Cucine wasn't promised or discussed. But the fraud and the misrepresentation is not on the contract. It's on that meeting that occurred in 2012. That is where the fraud took place in the misrepresentations. It is not about the contract. The contract for the fraud claim was really just a tool to advance his earlier misrepresentations, since he's already been doing the work for over a year and a half. All of his emails are signed by Minimal. They have Minimal Cucine blog spot link underneath. And then when you get the contract, it states Minimal. There's no other vendor who's listed. So the misrepresentations were collateral to the contract, which is where the fraud lies, as opposed to being a part and in the contract. With regards to the home license issue, Mr. Bellotti is an unlicensed general contractor. Canova is an unlicensed general contractor. And the work that they did was remodel the kitchen and bathrooms, as well as the bedrooms of Ms. Dhcr's apartment, which included installing and building entire cabinet structures that was attached to a bookcase, as well as putting in an entire island that was connected by 2 steel beams. This was not just decorative work or painting that is excluded from the statute. And quite frankly, the court in itself, in granting the summary judgment motion, pointed to one particular case.
Counsel, I'm going to ask you to wrap up because we're out of time.
Sure. Well, pointed to a particular case that's in the brief that basically denied summary judgment because work being done was a question of fact in determining whether it was just decorating work or remodeling, which is covered by that statute.
Thank you so much.
Thank you.
I'm going to try not to mangle this last name, but I'm going to give it the good old college try. Counsel Sewell.
That's right. Marwan Sewell for the respondent and defendants in this matter of Muchmore and Associates. May it please the court, thank you for your time this afternoon. What we have here today, contrary to the appellant's averments, is a very simple and garden variety breach of contract dispute dressed up as a fraud claim. The written document between the parties calls for the delivery of custom millwork from Italy to the defendant's condominium in Soho. And that's precisely what happened in this action. And if you look at the record, it was actually the plaintiff who failed to comply with the obligations of the contract by failing to pay about a quarter of the contract price.
Counsel, why is your client entitled to any payment whatsoever, given the fact that he had no licenses and his company had no licenses?
So, Your Honor, he was working, or his company was working under the license of a general contractor, or more importantly, under the New York City Administrative Code, because he was essentially, because they were delivering kitchen products, appliances, and decorative goods, they were not required to.
Were they installing?
Millwork isn't decorative.
We would argue that it is decorative.
That is custom cabinetry. It is very expensive. It is more expensive than pre-made cabinetry. Are you kidding me?
Well,
decorative is throwing a corbel at the end of a cabinet and saying, "Oh, now I've created the French country book." That's decorative. But creating an entire cabinet system and an entire island that is secured by beams is not decorative. By no stretch of the imagination, counsel.
We would argue that the cabinets and the millwork were all manufactured in Italy, which is what I think all the parties agree that is the case. And the installation was ancillary to the manufacture in Italy. They also delivered appliances. They delivered. Yes, Your Honor.
Did they have to remove anything in order to make these installations?
Not that I'm aware of, Your Honor.
To completely raw. Did they have to finish the walls or anything like that?
I believe the general contractor did that. I don't believe that there's anything in the record indicating that my client had to do any of that work.
And your client did no plumbing work?
No, I do not believe my client did any plumbing work. I believe they installed a shower and appliances.
My understanding on the record is that either Mr. Bellotti actually did electrical work in the space, so that certainly isn't simple, cosmetic installation. And you're not wrong. I mean, appliance installation per se, you don't really need a license, but there was other work here.
Unless it's a gas stove.
What I'm raising, sir, isn't there something in the record where the expensive cabinetry from Italy was particularly some of the drawers in the bedroom were actually using double-sided tape? Does that sound like expensive millwork to you?
Your Honor, this was millwork of the highest quality. I think the deficiencies that the plaintiff allegedly pointed out were not supported by any evidence in the record. They alleged that they sustained hundreds of thousands of dollars in repair and other costs, but they could not substantiate ever having paid them. They never produced.
Didn't they pay $37,000 of repair work?
They alleged that, and they were credited for that amount.
For brand new millwork, you did not have $37,000 worth of repairs.
Your Honor, I'd like to point out that in addition to being credited for those, for that amount of repairs, our client was unable to finish the punch list work because they were terminated essentially at substantial completion. So they would have repaired any small smudges or removed any double-sided tape, and there is testimony to that effect in the record. Again, I think that I worry that the appellant is trying to move the ball here. This is a very simple contract. The contract reflected the intent of the parties, and my client fulfilled their obligations under the contract. With respect to delays and other allegations, first, under New York law, in order to make a claim for delay damages, the plaintiff would have to demonstrate that there were no other concurrent or competing causes of delay, which they could not. The record is replete with evidence that they fired one architect and hired another, that they fired a general contractor and then hired another, and that buyers did not want to purchase the apartment, not because of any issues with the millwork. In fact, the plaintiff made a big deal about how wonderful the kitchen looked, Buyers were afraid to purchase the condo because of the cost that the plaintiff attached to it, millions of dollars above the market price at the time and what she paid for it. And then with respect to this alleged fraud claim, if you look at it, it's nothing but a repetition of their breach of contract claim. They've alleged no ancillary obligation or collateral obligation that the defendants were required to or promised to perform. And most importantly, they've never been able to establish that there are any issues of fact with respect to the elements of fraud. They've not demonstrated that there was any fraudulent intent, that there were any damages arising out of this alleged fraud, nor that there was a reasonable reliance on the alleged use of this millwork that only the plaintiff alleges she understood to be a term in the contract. In fact, when she was asked about whether or not representation had been made to her about minimal cucine millwork at her deposition, she responded that no such representation had been made. This is a very simple case, and that's the reason that it was decided on summary judgment. The plaintiffs could not produce any facts or issues of fact that would take this case to trial. We moved for summary judgment. The court correctly dismissed their causes of action for breach of contract because they could not prove any damages, nor could they prove that any delays were caused by my client. And the fraud claim was dismissed because it was duplicative of the breach of contract claims. And again, thank you, Your Honors.
Thank you so much. Okay, Mr. Polito, you have 1 minute.
Sure, I'll do my best to try to address as much as I can in that 1 minute. To begin, Mr. Sewell commented that there was apparently a general contractor he was using a license for before. That's news to me and nowhere in the record. So I don't know what that is. I think I want to address also that Dhcr Wugalter had testified, and this is the general contractor on the project, that she submitted a certification for application to get paid. The total at that time was $3 million that had been paid, and every change order that was submitted and part of the record was part of that certification application showing that payment was made. She testified to that effect as well. With regards to this being some simple case, unfortunately it is not. As much as respondent wants it to be, it is not, because you have many questions of fact based on, unfortunately, sort of a he said, she said scenario here. And that is why the court below erred, because this was not the case for summary judgment when you have this many facts in dispute. And that's where I guess I'll stop unless there are any other questions.
Thank you so much. Have a good evening.
Thank you.
Lopez versus Shea. Mr. McEnany. You have 5 minutes.
I apologize, Your Honors. Hopefully you can all hear me.
Yes.
I'm like kind of hybrided here. I have the video working, but the audio is not working. So I'm doing that through the phone. So I hope there's no delay.
All right. If you begin to hear an echo, I want you to turn off the computer and we listen to you by phone only. I'm surprised it's not echoing already. Okay? You may proceed.
I'm Timothy McEnany for the appellant Detective Lopez. May it please the court. The lower court's decision was based on a material factual error here, which turned an approximately 12-month gap in treatment, which was miscalculated by the medical board as 18 months gap in treatment, I'll get to that later, into a lower court created gap in treatment of 7 years. The decision stated, this is at record page 11, the decision states that Detective Lopez's returned to full-time NYPD duty status shortly after sustaining his October 20th, 2011 line of duty injury and remained in that status through 2018, as if he had returned to full duty status for 7 straight years after his 2011 line of duty injury. In fact, though, Detective Lopez was on modified duty status, either limited capacity or restricted duty during 2013 and again in 2017 for a total of over 500 days. That's 2 full work years between his 2013 discectomy and his retirement in 2018. He was also permanently medically restricted and never returned to full duty after April 19th, 2017, until his retirement in 2018. This is all during the period which the lower court alleged that Detective Lopez was working full duty status. He clearly wasn't. Moreover, Detective Lopez showed that he took extensive emergency days off for his injury between December of 2011, that's a month and a half after his line of duty injury on October 20th, 2011, and March of 2013, and was already receiving conservative treatment for his back during the time that the respondents alleged the gap of treatment to have occurred. Approximately 230 days off because of his back pain. That, the court can take judicial notice, is also almost an entire work year.
Counsel,
This is within a 15-month period.
Counsel,
I'm sorry.
Yes,
Judge Schulman has a question.
Oh, I'm sorry. I appreciate the strategy that the record seems to reflect Detective Lopez utilizing, because he did not want to appear to be a chronic absentee police officer, because it would affect his status as a hostage negotiator with an elite unit. I appreciate, but the medical board in doing this retrospective analysis was analyzing two discrete periods. In other words, it was your client's goal to have the ADR go all the way back to his third LOD accident in 2011. And between 2011 and 2014, notwithstanding the dates that you've described for his absences, for a variety of reasons, there, and I use the quote in the record, there's a paucity of medical evidentiary corroboration. No MRIs, no surgeon's reports, where someone would say, you know, I recommend surgery now, a laminectomy between 2011 and 2013, although you're holding off because you want to work. You get the point. And also between 2014 and 2016, the lack of surgeon type reports.
2014 is when he had his
surgery. I understand, but there were two gaps that the medical board was looking at, sir, where there was the absence, and while you have the days off, there could be a variety of reasons for why they're days off. The issue is they could not find the medical corroboration for that during those periods to link in 2018 to go all the way back to 2011. So wouldn't it be within their discretion? Wouldn't it be within their discretion in analyzing this? So it would not necessarily be arbitrary and capricious in this context? Doesn't that make sense?
Part of what makes that determination arbitrary and capricious, Your Honor, is the fact that there was evidence of treatment in 2012 when he first started receiving Percocets, pain medications for his back problems, in addition to the absences he was able to document. There is no contrary evidence in the record. There's nothing from his supervisors, nothing from anybody at the NYPD to show that he was not, in fact, taking this time off for the reasons that he stated. There's nothing to undermine that in any way, nor is there any reason to call his credibility into question. The medical board's not there to make that type of a credibility determination in the first place. So he did show that he was treating within 1 year, and under this court's jurisprudence, a 12-month gap in treatment is not a basis for a denial of causation. It doesn't break the causal nexus here.
May I ask you another quick question? I'm sorry. Why did he withdraw his ODR application? You know, when you weigh the difference between ODR and a straight pension, obviously an ODR would be more money. Am I correct?
No, ODR is less money. ODR is 50%.
Oh, it's less money?
Yep, ADR is 75%, and that is federal tax-free in addition to being state and municipal tax-free. So it's a much better pension, a much more remunerative pension than an ODR pension. The reason he withdrew the ODR application is that it was not, he didn't submit that application, Judge. The medical division, the NYPD medical division's physicians who treated him and assessed him as being disabled from his line of duty October 20th, 2011 injury, which they determined, they put in the application, said he's not fit for full duty. He can't be a full duty police officer anymore because of these conditions. They submitted it. He didn't want to accept an ordinary disability pension because it's less than his service pension would be, and he had enough time on to take a service pension in the interim. It's dramatically less.
I see.
So that's why he withdrew it. I hope that answers your question. So the decision, the decision states that he returned to full duty for 7 years. Clearly, that's not true. It was 12 months, if at all. The 18 months that the medical board asserts is based on the fact that that's the date between his line of duty injury and his first MRI. But MRIs are not the only treatment one receives. He saw a doctor for back pain, got back pain medication. He was on it as of December of that year. So
counsel, you're saying, if I may, you're saying that the fact that the plaintiff received painkillers in 2013 is sufficient to establish that there was treatment, ongoing treatment?
It was 2012.
2012.
December of 2012. So that's roughly 12 months after his line of duty injury.
It wasn't 2013.
It was not 2013.
But my question is he got a prescription. Was that the full extent of the treatment, quote unquote?
Well, he saw a physician for that prescription who prescribed that for his back pain. So I think that does qualify as treatment for the back injury that he sustained.
The medical board didn't agree, am I right? That they found it insufficient proof of treatment.
They declared that insufficient proof of treatment during that period. The NYPD medical division doctors have a different opinion. The medical division doctors, whose job it is to determine whether someone is fit for full duty, filed his disability application on their own initiative. They officially ascribed all of his treatment for his spinal injuries, including both his 2014 discectomy and his disabling 2016 spinal fusion, to his October 20th, 2011 line of duty injury. Both surgeries were paid for by the NYPD because of the medical division's own determination that they were necessitated by his October 20th, 2011 line of duty injuries. And the NYPD medical division doesn't authorize treatment for non-service connected injuries. So this is etiological proof from their own physicians, which constitutes competent medical evidence on the issue of causation in favor of the appellant's application, despite the medical board's view. The medical board, by the way, at one point in respondents' papers, they described the medical board as independent or objective. They're nothing of the kind. They're employed by the police pension system, and they're there for decades. There's nothing independent about them. They work for them.
You'll have time on rebuttal. We're way out of time.
Okay.
Okay. All right. Ms. Zalon, the floor is yours.
Thank you, Your Honor. Good afternoon. The burden, and this burden is on Lopez, on the petitioner, not on the medical board or the Supreme Court, is to establish as a matter of law that he's entitled to ADR benefits. That's because the Board of Trustees denied ADR by a tie vote. So that's his burden. The medical board, the medical board listed the categories of information that were lacking that would have been important to establish a causal connection and were not there. And they included the return to full duty right after the injury. The only treatment was an ER visit the day of the injury, which, by the way, described back pain, but no leg pain as occurred later. And there is, after remand to the medical board, and the medical board considered this case on several occasions, there's one reference to a prescription in 2012 without any detail, apparently from the primary care physician. The medical board looked at that and said that was not sufficient evidence of causation. And of
Counsel,
course,
let me just stop you there, if I may. So your adversary points to the Percocet prescription as proof of treatment. And could you just elaborate on that, please?
Well, the medical board looked at that. That was the subject of one of the remands and said that, took note of that prescription and determined that it was not, it does not, the record of it does not explain what it's for, how much it was, and it was actually, as counsel appropriately conceived, it was about 14 months or 13 months after the injury. And there is no medical record from that doctor to explain why that medical visit occurred. There's no affirmation, there's no medical report, there's nothing to say, my patient came in, he's been having chronic pain for a year and he's been trying to, that kind of evidence that you might have if you had documentation that connected that prescription to the injury.
Is there anything in the record that shows more than one visit to the doctor to get the Percocet prescription?
No, the only medical treatment of any kind that was cited by Lopez was this one prescription in 2012. Other than that, the only thing that happens is in 2013, he then goes to the ER and ultimately has the first of 2 back surgeries. And of course, the other point that's important here is that he returned to full duty after the 2011 injury. The Supreme Court misstated the end of the duration of his full duty as 2018. And that's true. He was disabled by the 2016 spinal fusion surgery, after that surgery. And there is, and the medical board was clear about that. That's the nature of the disability, was his limitation in movement after that surgery. So the thing that's under review is the causation of that disability, and Supreme Court properly, without regard to the court's citation of a 2018 date, the court clearly understood that the return to full duty after the injury, not only after the injury until the spinal surgery, so that's the period of the paucity of evidence from 2011 to 2013, and then in 2014 to 2016, full duty, all that time, that the court understood that the medical board's understanding of his use of full duty and his the gap in treatment and the paucity of treatment was the basis for the medical board's decision, and that does not establish as a matter of law that the Board of Trustees determination has to be overturned, and that was Lopez's burden.
Counsel, can you explain your adversary's point that the in-house police surgeon approved the surgeries and covered them? He's claiming that the approval of those surgeries or giving the full benefits of those surgeries suggests that they were linked to the line of duty injury. Do you agree with that?
Well, the prescription, essentially the certificate to authorize those various procedures, and they list the line of duty injury because the police department predicated it did need to predicate the treatment on an injury, a line of duty injury, and it did cite that. But there was no medical opinion rendered by any of the doctors that analyzes the cause of the injury, cause of the ultimate disability as tied to the injury. It's just like It's like a bare prescription.
I'm trying to wrap my head around that. So on the
Yeah.
one hand, the medical board, in order to cover the medical procedures that their officers need, will document it as a line of duty injury so that the officers can get treatment. But then when the same officer seeks to have those injuries considered for the purposes of accidental disability retirement, now, no, this doesn't qualify for that. That seems really like you're trying to have your cake and eat it too.
No, that's not actually how it works, Your Honor. What happened is the medical division of the NYPD listed the 2011 injury as a line of duty injury to authorize the various treatments. The NYPD knows that an independent entity, which is the police pension fund, has to make the ultimate determination of the retirement benefits. So that is not, they are not bound by the.
Yeah, I certainly, having sat on many of these appeals, understand the process. And what I understand is that they seem to think that they can operate in these two separate spheres and that these two circles never cross each other. And they do, because you cannot, everything that those of us in the legal profession who oversee civil cases know, that the sequelae of back injury is an ongoing process. It's not a stagnant process. You get injured, and whatever the injuries is on the day after you fall, that's the only injury you're gonna have. And it's clear from the evidence here that this officer, over time, this back injury became worse, such that radiculopathy developed, and he now has shooting pain going down his legs. And it seems perfectly reasonable to me that the police department would have concern of having a police officer with a gun in his hands and having sudden shooting pain coming down his back from back injury. So all of this kind of is interconnected, and this attempt to create these separate circles that don't intertwine is just not realistic and not the way the world works, right?
If you had a situation where a court were entitled to substitute its judgment for the medical board, that would be an analysis that one might do. However, there's other ways to look at it. Now, remember, Lopez's burden is to establish entitlement to ADR as a matter of law. An equally likely interpretation is that,
and so
there's no belief
that if counsel, just to make sure we're both on the same page, for him to establish that, he has to show that his disability arose from a line of duty injury, correct?
Yes.
So then the ultimate issue is whether there is sufficient evidence in the record to support that his injuries were a line of duty injury. And whether the decision to not grant it, whether that is, arbitrary and capricious in light of the evidence.
So
isn't that what we have to decide?
Let me jump into this, counsel, just for 1 second. So the problem here is that the 2014 accident, that I'm going to call it an accident, all right, that Lopez sustained was deemed not to be a line of injury duty, right? That's when he was transporting the boxes, the little refrigerator, and the little desk. So then, because it's out as a line of injury duty, then what we have in question is the relationship between the 2016 leg and back pains and the radiculopathy and everything else, and the 2011
or sought to obtain disability based on the 2011 injury. I think that's what happened.
Right.
By the way, you know, back injuries, who knows? There's a note in the 2016 examination by Dr. Stieber that Lopez had a fall while he was on a cruise ship, and he was treated for the by the doctor on the boat. You can see that cited in a footnote in our brief. I mean, the fact that
That's all post. That's all post back act. That's all post back surgery, correct?
No, that's not
That
post.
fall on the cruise ship was post back surgery.
No, that was post the 2013 surgery, which was successful, and he returned to full duty. It was not post the 2016.
Right.
Surgery. Is there anything in the operative report relative to causation that says this is the outcome of the 2011 line of duty injury?
No, Dr. Stieber is the spine surgeon, and he cites, just contains a reference to the 2011 date in a couple of requisitions. There's one where he lists the components of a type of surgery that would be, and he lists like the insurance codes that would be covered. So he's doing the same thing the NYPD is doing. He's citing it as the basis, but nobody is doing an analysis. And I think Justice Shulman's point that there's no medical report in there citing any explanation of how this 2016 disability could be caused by the 2011 injury, especially because he not only was there that lengthy gap in treatment, but there was a lengthy period of full duty, and indeed it is the medical board's determination of credibility. They're the ones who interviewed the petitioner, examined him. It is absolutely their authority to analyze credibility here, because the fact that he didn't take sick leave and he now comes back and says, oh, what I did was I actually was sick. I actually was in pain, but I didn't want to label my days off as days from sick leave. That absolutely is the province of the medical board.
Thank you so much. All
Thank
right,
you, Your
Counsel,
Honor.
you have 1 minute on rebuttal.
Okay, so first point, Your Honors, is that this court may absolutely substitute its judgment for that of the medical board on issues of causation. They're entitled to no deference. The deference they're entitled to is on calculations of disability, whether someone is or is not disabled. That's Borenstein. They don't get any deference on causation, so this court can make that determination itself on the record. The assertion by counsel just now that he returned to full duty, again, we addressed that earlier. He was for a large portion of time not full duty, obviously dealing with his issues with his back. In this case, under Salvia and Boda, this is roughly a 12-month gap in treatment. Were he to show no treatment at all for that amount of time, it still would not be sufficient grounds for a denial based on gap in treatment. The court below clearly misconstrued the actual gap in treatment as 7 years, not 12 months, and based its decision accordingly, because you can see from the way that it addresses the three cases we cite in our brief that it understands those holdings and would have otherwise applied them correctly. Here it was an error of law, a mistake that this court should correct.
Okay, thank you so much.
Thank you.
Thank you. People versus Albert Cotto. Counsel for Appellant, you have 4 minutes.
Good afternoon, Your Honor. Natalie Ray of the Legal Aid Society for Mr. Cotto. The question is, this case is not whether the court below should have granted an indefinite adjournment pending an Article 10 proceeding. This court has made it clear that it doesn't find that court should do that. The question here is whether the court should have granted a very limited request for an adjournment consented to by the people for a very specific purpose, the purpose of receiving the psychiatric evaluation ordered by the CTR in the Article 10 proceeding. It is our position.
Counsel, if I may, was this preserved below?
Yes, yes, Your Honor.
The due process argument?
Absolutely, Your Honor. In our reply brief, we actually quote the language used in our papers below, referring to due process. These arguments.
Counsel, this issue has been decided by this court numerous times. I know I certainly have been on similar appeals, and we have consistently rejected this argument. Why should we overturn ourselves here?
Because, Your Honor, this is not the kind of cases that where you have ruled in those. In this case, unlike the others, we had a lot of information. Generally speaking, the cases come up and say, there's an Article 10, it's pending. Our position is that this court that all phases of an Article 10 pending proceeding are not alike. You have the first large group which go before the MDR. Then you have 9.3% only that go to the CTR, right, to that review committee. And out of that 9.3%, they decide on how many are going to go to this psychiatric evaluation. So these are different phases, and we would ask the court to draw a line at these different phases, because
draw a line for everybody across the board? You're saying we should not take into consideration a case like this one, where it is clear from this defendant's prior cases and the case that he has on before us that there is no need to wait for determination in order to make a proper SORA assessment?
Well, I disagree. First, I'm not asking you. What I'm asking is that the court, not in all cases, we are here in the nine.
So then explain to me why this defendant is deserving of that. Why should we make that decision on this case for this defendant?
Because in this case, we have more information regarding the phase of the proceeding, and it's not about the offender. The fact that one would say that he would be a 3 anyway. My position is the SORA is made to protect the public, right? It's not a shaming. It's not.
So, counsel, taking that into account, given the fact that the release date of the defendant was imminent, what would have happened here if the SORA hearing was adjourned and there was no determination as to his was it mental health?
Correct. So I don't know of course I don't know, we wouldn't have known at that time what the psychiatric evaluation would have been. But
Isn't there an obligation of the court to make a SORA determination before the release date?
Your Honor, only the release into the community. And because the purpose of SORA is to protect the community. It's not about my client being deserving. In fact, the least deserving you would find him, the more dangerous he would be considered to be, and the more unlikely he would be to be found to be released at some time. You cannot, it's the protection of the public. And when in some cases where this court is found.
I'm still at a loss for how the public is protected by granting your client's application. I don't understand that.
The public is protected because he's not living within the public. As long as he is detained, whether it's committed, civilly committed, or incarcerated, he is no danger to the community.
So, if I may, this is Justice Rodriguez. Part of your argument relies on the position that it was very likely that he would be civilly committed. But at the end of the day, that's speculation, isn't it?
At that point, it is speculation. But why, at that point, in this particular, what I'm saying is that there are times, I'm not in 91% of cases, right, that go to the MDR only. I completely agree. I mean, I don't agree because but I accept your court's position. But why have a SORA level? A SORA level is not a grade. The purpose of the statute is to protect the public.
Counsel, I want to go to dates. I want to go to hard numbers.
Yes.
So the SORA hearing was initially scheduled for February 2nd. The court did grant an adjournment.
That was for a different reason. Nobody was ready.
But the court, counsel, the court did adjourn the case to what date? February 23rd. The release date is scheduled for February 29th.
Correct.
Nothing was happening on the mental health evaluation. Therefore, how is the public protected by not holding a hearing on February 23rd and allowing this person to ostensibly be released on February 29th, but 6 days later?
Okay, so at this point, again, it's not like there was just an Article 10 pending. He was within the less than 9.3 people, 9.3% of people who are going to this CTR and the psychiatric evaluation. It's a completely different set of facts. And in fact, it is 6 years later, and my client has a SORA level. He has never been in the community. And to say that he will always be a 3, which is what this court has said at times, if you're going to have an override for a prior sex crime, you have that at the time of sentencing, Your Honor. And in nowhere do we accept having the SORA hearing at sentencing because there's a 3 override for a prior. That's not what SORA is about.
I tell you, counsel, you're not making any sense, if I may be so bold as to say that. You're talking about a sexually violent predicate, a violent predicate sexual offender.
Correct.
Who, come on, 6 days before he's released, and you wanted an adjournment until when? Until he's out on the street.
Your Honor, the DA in this case consented to an adjournment pending for this psychiatric evaluation. So I may not be making sense.
Let's hear from the other side, and you'll have additional time because we are now repeating ourselves in argument. Counsel, I'll hear you in opposition. You have 4 minutes.
Good afternoon, Emily Aldridge for the people. This case is in sum and substance no different from the many cases that this court has already ruled on this precise issue. So if that's the case, why on earth would the people have consented to an adjournment in this situation and allow them to come in here with that argument? I obviously was not that assistant. This was a letter that they received the night before. This sounds like an off-the-cuff statement by somebody who wasn't quite sure how Article 10 worked, quite frankly. For example, the adjournment was for the doctor's evaluation, but the letter that was sent with counsel's letter said that it was a possibility. He may be referred to a psychiatrist. That wasn't even the procedural posture at the time. The letter mentioned 3 possibilities that may happen. 2 of the 3 were released into the community. So that prosecutor's single line is not dispositive. The letter that he received was 2 weeks prior to this. So again, this is hardly an advanced state posture when just 2 weeks before he gets the letter that this is going to the review team and may be referred to a psychiatrist. This may happen. This may happen. And this was asked, and although there's talk now of asking for a review subject only, an adjournment only to the psychiatrist review. At the time, we didn't know if there was going to be a psychiatrist review. That was only a mere possibility. And in that letter, counsel asked for this case to be adjourned while the review was pending. It was not so limited as counsel is now stating on appeal. At the time, it was basically looking for a complete adjournment, just like Gillette, just like Powell, just like Brown, just like Thomas, just like this court has decided over and over and over again. And if there are no questions, I rested my brief. Thank you.
All right, Monsieur, you have a minute on the bottle.
The DA consented for the limited purpose of receiving the psychiatric examination. And I will distinguish again from all these cases in the past because of the posture of the Article 10. And there is a way of having, if the court wants to have a temporary hearing at this point and a temporary level, should my client be released, fine. There is a subsection in 168L8 that permits the court to have a SORA hearing after he's out. Therefore, it could have been a week after he was out that he would have had the hearing. Having a SORA hearing and having a level to protect the public on someone who is not in the community is inconsistent with the purpose of SORA and the language of SORA. Thank you. Yeah.
Thank you. Shanghai Yongrun Investment versus Kashi Galaxy Venture Capital.
Good afternoon. May it please the court. I'm Katie Burkhardt Kramer of DGW Kramer LLP on behalf of the appellant here. The lower court's errors here fall into two general buckets. The first bucket is the misapplication of New York law. And within that, we have the misapplication of the standard for a motion to dismiss based on documentary evidence. And then also a misconstruction of the law regarding the recognition of foreign money judgments. Second, we have the big picture issues, which are the cases from other jurisdictions within the country with regards to judgments coming out of the People's Republic of China, and also the very serious international comity concerns that we raised in our brief and that were also very well articulated in the brief of the 15 law professors who spoke up as amici in support of our position. So turning first to the issue of documentary evidence and what is the New York standard for that, the lower court here simply just got it wrong. The country reports that the lower court relied upon are not documentary. They're summary conclusions, they're politically motivated documents. There's numerous other court decisions that reach that conclusion on the issue of country reports, both in the context of judgment enforcement and also immigration cases. If you look at the purpose of the country reports, why are they issued by the government? They're issued to be used by Congress in apportioning aid. They're not meant to be findings of fact. They're not documents that should be used to take judicial notice of any particular facts. So they simply are not documentary here. What I think is a good example of something that is documentary for purposes of a motion to dismiss would be if you had a contract that said the contract is for the services of, I'm going to do X. And somebody comes in and says, and granted, because it was not converted to a motion for summary judgment. There is a lot more evidence that could have come in. The court erred by granting this motion to dismiss and considering the country reports to be documentary evidence and sufficient to make a ruling at this early stage of the case. In addition,
has one of these documents ever been utilized by any court to make the declaration made here?
Not that I'm aware of, Your Honor, and the cases that were cited by the lower court and also the cases that were cited by the respondent, there are no cases where the country reports were determined to be documentary under the standard of CPLR 3211A1, which is what we're looking at here.
So, counsel, I'm
And
going to ask you.
go ahead.
I'm going to ask you a different kind of question. You characterized the country reports as politically motivated. When I was going through the two reports in question, I saw them more as a human rights analysis. How does that impact a commercial litigation, if it does in any way?
That's exactly right. The orientation of the country reports is geared towards understanding human rights issues, perhaps the criminal justice system. It's really just, it's not on point for the issues that we're looking at here. The understanding of what's the functioning of the civil judicial system. If you have a business contract, a business dispute that comes into the court system, what is the court system going to do?
Excuse me, but if the judicial system can be perverted in all of those areas, the criminal area, human rights, etc., what is to say that it can't be perverted in a civil case?
But, Your Honor, the problem here is that we need to look at what the lower court decided. The lower court decided that based solely on the country reports, he could make the determination that as a matter of law, no civil judgment coming out of China should be recognized by the state of New York. And then we do need to look at the potential ripple effects of that. If the country report—
Why don't you discuss those ripple effects and how many contracts by U.S. businesses could be affected in China by a ruling?
Exactly, Your Honor. There's the important question of comity between the United States and China, but there's also broader ripple effects. But I'll start first with the potential ripple effects for U.S. litigants. If a U.S. litigant has a judgment that's issued by a U.S. court, a New York court, a different court, somewhere in the United States, which they want to have recognized in China. Recently, U.S. judgments have been recognized in China on the basis of international comity. This idea that we'll recognize your judgments because you recognize ours. If New York stops recognizing Chinese judgments on an absolute level, not on a case-by-case level, I think everybody agrees the case-by-case is fine. There are going to be certain situations where maybe there is a problem with a particular case, particular proceeding, but the problem here is that it's an across-the-board determination that was made by the lower court. So if the lower court's decision here is allowed to stand, it will have a very negative effect on U.S. litigants and U.S. businesses that are trying to enforce judgments in China. They'll have a much harder time doing so. There will also be a much harder time enforcing judgments from other countries. If the language from the country reports here that related to China is deemed sufficient and documentary, that gives a very strong basis for wrongdoers from other countries around the world to try to avoid the responsibility by saying there is similar language in the country report for my nation. And this is laid out in very good detail in the amicus brief. I think it's almost 200 countries where the country reports use very similar language to what we saw for the Chinese country reports. And then if that's sufficient, those wrongdoers from countries around the world will also be able to try to avoid their responsibility for a duly obtained judgment that was rendered against them.
Counsel, could you just, may I, or do you want to go?
Go ahead.
Your adversary says that the court should not use a quote unquote retail approach in assessing whether due process is afforded. What do you say about this retail approach perspective?
I think that if the analysis is being done under the mandatory non-recognition language of the uniform law, then yes, then it can't be a retail approach. Then those things just don't match. But the law intentionally has another section that really is a retail approach. And I think that that here is what allows this court to comfortably overturn the lower court's decision, to say there's not going to be any sort of danger or anything like that if the lower court's decision is reversed here, because in the future, litigants and judges can rely on the other portion of the statute that allows the case-by-case analysis. In particular, we can look at the amendment that has been done to the Uniform Act that was adopted in New York. I think it was about 6 months ago that it was enacted in New York, that allows case-by-case analysis of whether there was a lack of due process or impartial tribunals for a particular case. So going forward, those arguments can be raised by defendants to say there was a lack of due process, there was a lack of an impartial tribunal in my case, and therefore this judgment should not be recognized. So if there was a legitimate basis, then those defendants would have that protection without having this wholesale decision about an entire judicial system that really is going to rock the international relations.
Thank you so much. Mr. Lee, the floor is yours. You have 6 minutes. Please unmute your mic so we can hear you.
Thank you very much, Your Honor. May it please the court. My name is Bing Lee. Looks like their position, the panel's position is that the systemic ground on the book, on the law book, does not mean anything. The court should not use it. That systemic ground is there for a reason. The reasons are clear. That applies exactly to the case like this one. That is, the whole system is perverted. It's controlled by the Communist Party, appointed the judge, and the judge has to agree to follow the party's rule and take instructions from the Communist Party.
Counsel, what case stands for the proposition that the entire judicial system of the Republic of China is so antithetical to due process that we cannot at all utilize the concepts of comedy that have been employed by this state for decades?
Your Honor, actually, the UFMIJRA actually takes away the international comedy from the statute book. It is in the proposed test of the uniform rule. And New York legislature chose not to put in the law book. So international comedy, Your Honor, is something where the statute does not specifically say, and the court may come in. But in this case, the proposed test of 1962 or the 2005, they both have the international comedy, but the New York legislature chose not to adopt it. So that, Your Honor, if I may I just tell the court that they have improperly raised the new argument in the reply. That is, the lower court applied the wrong standard in deciding the motion for dismiss. And based on this court's precedent, that is not proper, and the court should not consider that. Even if the court would consider that, the lower court has all the exceptions to convert the motion to motion for dismiss without giving notice. Number one, the first exception is that this case, the issue is that it's a question about the law, if not exactly of the law, but definitely it's not a fact. That's the Seventh Circuit held in the Ashington case. So then CPR 11B and the D comes in to allow authorize this court to look at anything. pretty much anything. The court could do their own independent research. That's in 4511D. Your Honor, now let's move to more important things about the independent judiciary, which we argued as a part of this due process or notions. The Court of Appeal, the binding precedent talks about the or notions.
The Court of Appeals has affirmed judgments for the Republic of China many, many times, counsel. This court has done the same. So again, I ask you, okay, because I know you understand that if this ruling were to stand, as counsel has argued and as the amici briefs have clearly articulated, it would have a tremendous impact on business between not just the US and China, but China and every other country.
Your Honor,
okay, so this is not a simple, you argue this in a very cavalier way, that we should just completely dismiss an entire judicial system of a nation with whom we do business with every day. There are existing contracts today between China and companies in the US that either call for the jurisdiction of a China court or the jurisdiction of a US court. This kind of ruling would have grand implications on all of those contracts. And so I am trying to understand, what is the underpinning for such a incredible decision that you want this court to affirm?
Yes, Your Honor. A number of things in Your Honor's question. Number one, the previous judgment upheld by New York court had nothing to do with this systemic ground. Remember that. Remember that. No case, no judgment about China has been affirmed on this ground. And nobody, I don't know why, has ever raised this ground. Number one. Number two, Your Honor, we cited—
I know why, but go ahead.
We cited in the brief the DC Circuit case saying that we will check the foreign nations' norms of due process to the great extent of our own notions and goals, but the robust international trade will demand no less. That's in the judicial opinion of the DC Circuit, cited in the brief. Your Honor, if I may I just say several other things?
So, counsel,
Yes.
are you positing that all Chinese judgments should be disregarded by New York courts?
Well, at least from this period,
because you did say retail, no retail approach.
That can't be a retail approach because
right. No, stop. So are you therefore saying that everything from 2018 forward should be disregarded if the judgment comes from China?
Well, Your Honor, it's only between 18 and the 19, because that's when the judgment was surrendered. So in other words, anybody can come to this court to argue that this judgment was surrendered in 2020, and therefore is not bound by this decision.
Because wait a minute, I want to understand that. So the only problem with China's judicial system only existed in 2018 to 2019, and miraculously it is now fixed?
Well, if the Chinese Communist Party
is that your argument, really?
Well, yes, Your Honor. Yes, Your Honor. If the Chinese government choose to do better with their system, to create the independent judiciary, let the judge make their decisions. Leave the judges alone. Let them make their own decisions. So now that comes to my next point, Your Honor. That is, the appellant is saying that even our United States, our own system cannot be completely political free. They're confused. They're confused with the political process in establishing the independent judiciary and the independence. We voted all the judges. We voters, but we do not control how your judges rule. The president, yes, appointed just federal judges. The Senate confirmed that.
You realize all of our judges are not elected, right? You realize we too have appointed judges.
Yes,
that the people.
But Your Honor, we voters do not control how your judges do your work. I voted the judge all the time. I do not. Your Honor, the next point will be the Ashenden dictum. The Ashton dictum is instructive. It says, we do not need to consider what evidence to prove whether or not their system meets our standard of due process. If they're from Cuba, North Korea, Congo, Iraq, Iran, and any other nation where the due process law, rule of law is open to question. That's in the Ashton case. So the Chinese judgment, the Chinese system fits into that dictum.
So, counsel, if I may, again, I'm sure you read the amici brief that was submitted by the 15 law professors, and they highlight 141 countries that kind of fall into the same category. Are you also positing that any judgment coming from those 141 countries should be invalidated, or not invalidated,
no, Your Honor.
Not enforced in the United States?
No, Your Honor. There are not many communist countries on the face of this globe.
But are you saying that only communist countries have bad judicial systems?
No, Your Honor. I'm saying that
we know that that's not true, right? So that can't be the test. Only if it's a communist country and has one of these reports do the judgments not count. So either we care about due process, whether the country is communist or labels itself something else. If indeed the true issue is what you're saying.
You know, I'm not equating communism with the lack of due process. I'm saying because communism system does not have an independent judiciary. The Communist Party is the law. It's the law of the country. It's not the. Yeah, I feel like, Your Honor, I address your concern. May I just briefly mention several?
Well, we're actually out of time, so I'm going to give you one more minute to wrap up.
Thank you very much,
We've asked
Your Honor.
you so many questions.
Once again, addressing Justice Gonzalez, I'm sorry, Gonzalez question, Your Honor. It doesn't matter. I mean, how much it affects other countries, because this decision will not affect their conditions because they are not the same. Yes, North Korea is the same, Cuba is the same, and Congo is the same because they're all communist countries, but not necessarily exactly the same condition. Back to the CPLR 32.
All right, no back to, we're out of
time.
We have your papers and we will consider your.
Just one quick second about 30.
Counsel, we are done. Your time is up. I have to move on now to the rebuttal time. Counsel, you may proceed. Ms. Kramer, you have 2 minutes.
Thank you, Your Honor. First of all, the lower court decision said nothing about a time limitation on the scope of the order. It said nothing about this is an order that only applies to judgments from 2018 and 2019. The court's order is sweeping. It's not time limited. If you read it on its face, it would go back in time and it would continue to the future without any sort of limitation. Second of all, if we were to apply the retail approach here, the due process that was provided in the Chinese proceedings was adequate. It met the standards of what was necessary, and I would posit that that's why the defendant did not present any of those retail arguments for non-recognition. The defendant was represented by counsel. There was a bench trial. There was an appeal. Ran the gamut. So there's no argument about shortcomings of the proceedings that were underlying the case here that led up to this judgment. And I think that's why
in the actual trial and in the appeal, did the litigant here raise any issues about there being any kind of underhanded political interference with their contract, such that some judge improperly weighed in on a case that they had personal connections to, that there was some kind of conflict? Was there any factual allegation below in China with regard to there being anything underhanded going on?
Not that I'm aware of, Your Honor. I'm not aware of that from the record, and I certainly have not seen that in the arguments that were presented by the respondent. And I would expect that if those arguments had been presented in the Chinese proceedings, they would have been presented here as well. So I don't believe so. I don't believe so.
Okay. Thank you so much.
Okay.
All right, next case for argument, 128 Histor LLC versus DHCR. Mr. Shanker, you have the floor and you have 6 minutes.
May it please the court, Your Honor. My name is Mikhail Shanker. I'm counsel for Appellant 128 Histor. And before I launch into my arguments, I have to bring to your attention a matter that was not raised in the briefing, but it appears on the face of the record. And as an officer of the court, I have to disclose that it appears to me that the court is without jurisdiction to consider this appeal for the reason that the notice of appeal that I filed is null and void, for the same reason as the appealed decision is null and void. At the time of November 2nd, 2020, oral argument of the appeal decision, counsel for tenant respondents, Mr. Gorman, notified the court that one of his clients was deceased at the time of the hearing. And he notified the court that he learned of this 3 days late, 3 days before the hearing. Specifically, respondent Yan Kam Lee was deceased, and as Mr. Gorman notified the court, was unrepresented deceased. At the court nonetheless continued, did not sever as against that deceased.
Counsel, I have to tell you, if I were you, I would deal with the substantive matters. I think these arguments fall flat, at least for me. So I would strongly suggest that you deal with the merits of the issues before the court. Why should these tenants who were evicted when they were alive not be compensated for their eviction? That's the issue.
Your Honor, I do want to put on the record.
Counsel, I need you to answer the court's question.
Okay. Yes, Your Honor, I will address with regard to the main argument that I have, that I consider there was a violation of due process in terms of the issuance of the monetary stipend without conducting in-person hearing. That was
again. Is there an issue that your clients demolished the building before receiving permission from DHCR and the Department of Buildings? Is that true?
We were required to take down the building by the Department of Buildings. The answer is yes.
Yes.
Correct.
Okay. This would really help if you just answered the questions.
Not prior to the application, prior to the DHCR.
I said prior to the decision being made.
Correct. Yes. The answer is
an application was made to demolish the building, and before a decision was rendered, your clients demolished the building, correct?
The answer is yes.
And by virtue of that fact, then there can be no dispute that all of the tenants then living in those buildings were, by virtue of that demolishing of the building, were evicted, correct?
The answer is
yes.
Well, I cannot say whether
there's no question about that. You didn't demolish the building and leave them in the building, right?
Absolutely.
They had to be vacated from the building before you could demolish it, correct?
You're right.
The statute says that if, counsel, the statute says that if you demolish a building, there are various formulas that the court can look to in determining how much of a stipend each tenant is entitled to. Isn't that right?
There is a DHCR bulletin that makes spells out a formula for calculating the amount of stipends. That's correct.
Okay. But does that bulletin say that the people who were evicted have to be alive when you finally pay, or that they're due money when they are evicted?
The key word is final order. They have to be alive at the time of the final order.
And what says that?
That is. 1 second. That is RSC section 2524, paragraph 2D.
And when was that final order issued?
The final order we maintain is the June 2017 order.
Okay. Go ahead. You can keep on.
I do want to point out to the court the matter of Deutsche Bank National Trust Company against L. Smith. It's 191 AD 3rd 950, jump site 951, where the second department dealing with a similar situation reversed the lower court, where it discovered for the first time on appeal that one of the parties was dead at the time of the issuance of the lower court's order. And if you look at appendix page 13 and 14, the court was clearly apprised that at the time of the hearing, one of the respondents was deceased, and there was no substitution of the estate for the respondent. And for that reason alone, the lower court could not have proceeded with deciding the motion sequence 5 of the matter, deciding the petition. At the very least, the court should have severed as against
Rodriguez, I have a question. Just to go back, when are you saying the final order was issued here?
June 2017.
Well, DHCR found that the final order was the October 17, 2013 order. And if that's the case, at that time, none of the tenants were deceased. Is that correct?
That was one of the two orders. Basically, DHCR bifurcated the proceeding, and they made a determination as to liability to versus, and then left the determination of.
I'll break up my question into two parts to make it easier. The DHCR, they found that the October 17, 2013 order was their final agency order. Is that right? That's what they found. I'm not asking you whether you agree with it. I'm asking you whether that's what they found.
I cannot answer that question. I'm not certain.
Okay, well, I can tell you that that's what my understanding is. And if that's correct, let's assume that that is correct, that the 2013 order was the final agency order. None of the tenants that are now deceased, they were alive at that time, correct?
Well, it's not clear. Well, it's not really clear to me because Mr. Gorman, who represents them, does not have a direct connection. He works
certificates. Didn't he provide death certificates that show that one of them died April 11, 2016, the other May 22nd, 2016, and the last one January 15, 2015, all after what the agency is saying was their final order in 2013? That's clear.
As to those individuals, yes, the answer is correct.
Well, those are the only ones who are deceased. As to everyone else, this is a non-issue.
Mr. Gorman is not aware. He doesn't have direct relationship with his clients. So
I know that you keep on focusing on Mr. Gorman, and I know that you think that's a good argument for you. But the rights of these tenants is the rights of these tenants, regardless of who represents them.
Absolutely, but we also we also have the rights of the individual who is now compelled to pay $1 million compensation or stipend. And there is, in terms of speaking about two different orders from DHCR, the 2013 order and 2017 order, there must be a distinction.
The 2017 order was a limited review on a limited issue.
But
and the hearing court was very clear to limit what they were looking at, counsel.
But
they did not open up the entire thing like you're intimating. That is not accurate.
In terms of the due process requirements and that should have been granted to us and accommodations, one thing is clear. With that, when you have merely determination on the liability and no numbers are mentioned, the requirements for versus the question whether there is a requirement for in-person hearing, evidentiary hearing, and versus when as opposed to those same due process requirements when the administrative body now actually solidifies its determination and puts a significant number on it, $1 million.
Counsel, isn't there a formula that's used pursuant
Yes.
to regulation?
There is a formula, but that formula was not.
So are you saying that the math was wrong, or that the formula shouldn't have been used?
We did object to the math, and we objected as to the number and identity of individuals who were tenants of record and who were entitled.
No, that's a different issue. I'm asking you about the dollar number. You're saying that there should have been a hearing, and I'm saying to you, for what?
A hearing for the purposes of this determining disputed facts that led to that fed into the formula.
Okay, all right, you'll have time for rebuttal.
Thank you.
Mr. Gorman, you have 4 minutes. Please unmute.
Now I'm okay?
Yes.
I used to volunteer, and then I was hired by Asian Americans for Equality to represent tenants in Chinatown. And from the outset of this problem, when tenants got a vacate notice issued by the DOB, we sought to restore the building with an HP action. And while that was pending, the buildings department came in and issued a demolition order. And then through the aegis of AFI, who was paying my fee, we sought to stay and reverse the demolition order and the hope of restoring the building to habitability, because that's AFI's purpose, to maintain affordable housing in Chinatown for its residents, regulated housing. That proceeding was dismissed, and then the demolition proceeded. The owner filed with with DHCR, a demolition perm application notifying that the leases and tenancies had to be terminated for the 8 tenants in occupancy. They identified the tenants who were in possession of the apartment.
I want you to stop for 1 second, because I want to make sure that that gets said very clearly. I want to make sure I heard you right. The appellants here identified these very same 8 tenants that they now complain of and question whether they were actual tenants. Am I correct?
That's correct. They were named by the petitioner and the appellant in this case. They were identified. And then the agreement that I had with AFI was that AFI would pay my hourly fee at a reduced rate, and the tenants had no obligation to me or to AFI with respect to attorney's fees. Once it was determined that the building was demolished, that it was no longer in existence. So no one had any economic interest beyond prosecuting the claim that the tenants were entitled to relocation benefits. In any event, all of this was reviewed by this court previously, and it went not only through the process of the Article 78 review, indeed it was remanded for an adjustment.
So Mr. Gorman, I'm sorry, just cutting to the chase a little bit. So as my colleague, Judge Rodriguez mentioned, the final and binding par order was in 2013, correct?
That's correct.
And the final and binding par order, inter alia, determined that these tenants were entitled to option 3 under the operational bulletin, correct?
That is correct.
And at that time, when the final and binding order was issued, these 8 tenants were alive and well.
Very much so. Okay. And the balance of it really that resulted in the 2017 order was a ministerial application of the relocation allocation formula. So it wasn't anything that was determinative. But in the interim,
and I'm sorry, and as I understand it on this record, the petitioner appellant had a full and fair opportunity to submit all the evidence, documentary evidence, or anything it chose in an effort to determine the equities of whether option 1, 2, or 3 under the operational building should be utilized, correct?
Oh, correct. Very much so, Judge.
Okay.
So I am just dismayed that the principal thrust by the petitioner was that somehow I was engaged in some kind of shenanigans. To what end, I ask? I have no financial interest other than serving these people, these families, and moreover,
Sir, I thank you for what you're saying, okay? But let me say to you, you have no need to apologize to this court, okay? And you're out of time, and thank you, sir. Mr. Ambrose. Ambrose. I think I'm messing up your name. I'm sorry.
That's okay, Your Honor. That's okay. Thank you very much. May it please the court. I'll just briefly address one point, which is one of the main points that the appellant makes, which is the claim that the three tenants whose estates are parties. I'm not talking about the subsequently deceased tenant that Mr. Schenker brought up as his first point in his argument, that their estates are not entitled to compensation because they died before the issuance of a final order. And I think that it's really this focus on which order of DHCR was the final order, I think really misses the point of the situation here. Now, as I've laid out in my brief, the purpose of this particular regulation about the estates of deceased tenants, the purpose is to prevent the estate of a tenant who was never evicted from recovering relocation stipends, because there was no harm, there was no injury to that tenant, because that tenant was not evicted during his or her lifetime. And the reason that the regulation talks about a final order granting the owner's application is that in the ordinary case, the owner applies to DHCR for permission to demolish. DHCR conducts an investigation and usually a hearing, and then an order is issued either granting or denying the application. And if the order is issued granting the application and all appeals are exhausted, the owner may then proceed to evict and then demolish. And that's why the regulation talks about the final order granting the application, because without the final order granting the application, there's no demolition, and there's no eviction and no demolition. Here, everything was reversed. Here, the owner was ordered to demolish by DOB, and then as a condition of receiving permission from DOB to demolish, because it had represented that the building contained regulated tenants, DOB directed it to apply to DHCR for permission to demolish. By the time DHCR got around to ruling on the application, the building had already been demolished. The tenants had already been evicted. So all of the tenants had been evicted by the time DHCR issued even the first rent administrator's order that was subject to administrative and judicial review. So in any event, the bottom line is that these tenants were evicted long before they died, and their estates are entitled to the same compensation that they would have received were they still alive today. Thank you very much.
Thank you so much. All right, Mr. Schenker, you have 2 minutes. Please unmute your mics. Can hear you.
I apologize. I just want to address one point, and I will not belabor this any more than it has to be. But Judge Manzanetti, you basically asked, you stressed the point that we ourselves listed all the tenants in the DHCR proceeding, and therefore we are stopped from claiming that these people are not tenants.
I didn't use the word stopped. But it makes it really hard for you to say who are these tenants when you name them yourself.
But to be true with you, to be honest with you, when you as counsel start a proceeding to evict someone, you obviously include everyone who has a connection that you have reason to believe has a connection to the apartment. That
like a lease. I mean, look, I mean, an attorney for a landlord such as this, unless that attorney lives in the building and knows all 8 tenants, is getting this information from his employer, the landlord. And where would the employer get all those names? From leases.
From the landlord, from the super, from the conducting an investigation. When you start a proceeding, you want the proceeding to be binding on as many people as you can get. But that does not in and of itself constitute a concession that all those people are not tenants of record, as opposed to occupants that without permission of the landlord. So therefore, when the order, $1 million order from 2017 came down, we are entitled to a hearing to determine who precisely we are paying to, who is entitled, that the people that we are not just paying to a name that can be very common in certain parts of the world, but we're paying to someone who's never even showed an ID or proof that that individual resided in the apartment.
Okay, thank you so much.
Thank you.
Next case for argument, Parker versus Trustees of Spence School. Mr. Oliveri.
Thank you, Your Honor. May it please the court, my name is Joe Oliveri, and I represent the plaintiff appellants Adam and Michelle Parker and their minor child DP. Your Honors, this case arises from the Spence School's almost unbelievable actions against a 15-year-old student entrusted to its care. I want to be clear what this case is about. This case is about holding Spence accountable under New York's generally applicable laws for publicly demonizing a 15-year-old girl for statements that it knew she did not make, for falsely telling the community that DP committed, quote, a racist anti-Semitic action that she did not commit, for doubling down and repeatedly publicly shaming DP, even though Spence privately admitted that her supposedly racist post.
Counsel, this is Justice Rodriguez. When is it that the school actually read the Instagram messages that were attributed to DP?
Sure. The school, DP's faculty advisor, Jana Krutzinger, read the post. DP shared it with her prior to the first assembly, and Ms. Krutzinger told DP that she should not share the actual post with anyone. In effect, Spence was, through Krutzinger, covered up what the actual post was and told her not to share it with anyone. So Spence had full knowledge before the very first assembly at which the school convened to tell the community that DP had made a racist post and to falsely describe that post. This is not a case, importantly, where Spence just accused DP of being racist or even of taking a racist action. Spence falsely attributed words that she did not speak. They said that she paired slaves and slave owners, Jews and Hitler, to create oppressed were pairs, and advocated and even joked about dressing up as those pairs. That just didn't happen. Those are false facts. So the lower court mischaracterized plaintiff's claim as defamation claim as just being about whether she violated school rules. That's not it at all. And it's not even about an opinion as to whether an actual thing is or is not racist, as Spence argues in the briefs. Here we have the false attribution of statements that she didn't make, the false characterization of those statements to the community. And Spence, over time, repeatedly doubled down on this false narrative about the 15-year-old girl. Spence even, I'm sorry,
Mr. Oliveri, did anyone at the school contact this child's parents prior to the assembly, in the first assembly in question, where she was accused of posting racist posts?
Sure. So Spence summoned DP to the head of school's office to meet with her, and DP's father joined that meeting in progress. During which time the head, or sorry, not the head of school, Michelle Krauthammer's office. During which time the adults in the room falsely characterized the post, accused DP of lying, and DP, understandably, as a 15-year-old girl being confronted by authority figures, she'd never been in trouble before. She broke down in tears. And after, during that meeting, Spence administrator said, "You must apologize to this African-American girl who claimed to be offended by the post, although she hadn't actually seen it." This is all before the assembly. DP did that the next day, hoping that, that would be the end of it, as a 15-year-old girl would hope and think. And that's the point at which she actually showed her true post to the administrator, to her faculty advisor, who told her, "Do not share this." Spence then proceeded with the first assembly, with the second assembly, and then even further, following that, the harm to DP was manifest. And as Spence later admitted, quote, the consequences were significant of what Spence itself characterized as an enormous mistake. After that, students believed what the school told them. The community is going to believe authority figures here. And what happened, DP was harassed. She was even physically assaulted at Spence. Spence and her parents pled with the school, please investigate this harassment, investigate these things. And Spence refused to do that, thereby breaching the harassment policy. Another point that I do want to make, Your Honors, is with regard to the breach of contract and Spence's failure to follow the disciplinary protocols. That failure is significant here because had Spence followed those protocols, they would have conducted an investigation early on. Had they done that, they would have obtained evidence like DP's post rather than suppressing it, and never would have convened the assemblies, sent a letter to the community, and branded this poor child a racist and an anti-Semite.
If I could just interrupt for 1 second, sir. This is Judge Mazzoli. Let me understand, when did they first read the post? At what point?
So Jana Krautzinger, DP's faculty advisor, read the post prior to the first assembly. Then the administrators, I believe, read the post between the first assembly and the second assembly, but continued with the false characterization.
Who convened the first assembly?
It was convened by the dean of the upper school, Michelle Krauthammer, as well as the director of institutional equity, Rebecca Hong, and another administrator.
And you're saying they did not read the post prior to convening that, is that correct?
They did not, Your Honor. Jana Krauthammer did, and she was there on the stage with the other administrators during that, with full knowledge of what the actual post was. I'm happy to answer further questions. I see that my allotted time is up. I'd love to discuss this case for a long time, but I yield to the court.
Do my colleagues have any additional questions for counsel? Not at this time? Okay. So Mr. Bogman?
Yes.
Did I say that correctly?
It's Bachman.
Okay, you may proceed,
Okay.
sir.
May it please the court. Your Honor, the trial court properly dismissed this complaint, which seeks to challenge Spence's judgment, their exercise of judgment, in responding to a controversy that was created by DP's posts.
So, counsel,
This controversy was created by a lack of, I've got to tell you, I was outraged by reading this case because, quite frankly, I think that the Spence School has missed an opportunity for a teachable moment with these students and instead created this firestorm. And this young girl gets labeled a racist for a comment that, quite frankly, is, I'm not as outraged by that comment as I am by the lady.
Well, Your Honor, the community was offended by it. And just to be very clear, we're here
So,
on a motion
counsel,
to dismiss.
let me say something else. The in the letter to the upper school parents, the dean of school said, despite our request, the administration was never provided with a copy of the post and relied on verbal representations. What we were trying to do is control the narrative a little bit. But then afterwards, at a later point, the head of school concedes, we didn't have the post, we didn't ask for it, we didn't read it. The consequences of that have been significant. If any of us were to do that in our position as judges and simply rely on what people said to us, if that was allowed in a court of law at any hearing or in any other place, it would be thrown out. It would be thrown out. The people who would be trying to perpetrate it would be thrown out on their heels. How do you go forward with an assembly without having the facts in front of you? This was a written post and the reliance was on a verbal representation. How can you justify that?
Well, they didn't, Your Honor. And we're here on a motion to dismiss. Okay, so I need to take the allegations in the complaint as true. They're not true. And the reality is we did ask for the
No, counsel, the head of school, Brizendine, established that the allegations, some of the allegations are definitely true because she said one thing to the upper school parents, and then she admitted subsequently that there was no request for the post.
There was a request for the post. If there were discovery, we would prove that, but discovery isn't necessary here. Look, the allegations in the complaint, we vigorously dispute. They are not true. The reality is that we exercised our judgment. We tried to find out what was in this post, which was, we were told, deleted. So we had no reason to believe that the post was even available. It is not true that the advisor read the post. But if we can turn back to the legal issue here, and the fundamental legal issue is, have they stated a claim? And as to the defamation claim in particular, they have not, because they need to establish for the oral defamation claim, which is slander, they need to establish that it is
Let's go to the easy one. Let's go to the breach of contract one, where there's a community standards committee that's supposed to be created to evaluate this type of alleged infraction, where that committee is never convened, where no investigation never takes place. What do you say about that?
I urge you, Your Honor, that we are here on a motion to dismiss and the complaint is not true. But what I say to that is, as a legal matter, the actual contract is the enrollment contract, and the enrollment contract does not require an investigation. What it says is that in the discretion of the head of school, if she thinks that a policy has been violated, someone can be disciplined. And additionally, that provision didn't apply because we're talking about a half-day home suspension. Okay, she was not a half-day.
So that was not talking about injury to this child. I mean, really, this is not the only injury to this child. She was ostracized and singled out. You didn't have to mention her name. Everyone in the school knew that the assembly was about her. Who are we kidding? It is outrageous. You do this not once, twice to a 15-year-old.
Your Honor, everyone in the school knew the allegations were already circulating in the school. And yes, the school held an assembly to try to control the narrative because everyone was talking about it. And that's what a responsible school would do, is they would have a meeting with, we're talking about 60 10th graders. They didn't have the post, Your Honor. They asked for the post and they didn't have it. I understand that that's the allegation, the complaint. It's not true. But nonetheless, as a legal matter, they need to establish that either the comments were slanderous per se, which they were not, or they need to establish special damages, which they have not established and cannot establish. So as a legal matter, Your Honor, the complaint needs, the allegations of slander need to be dismissed. As to the contract claim, the contract does not require an investigation for someone who stays home for a half-day home reflection. The contract does not require an investigation for harassment, which is not sexual in nature. The school did investigate, by the way, and if you read the complaint carefully, you can tell they investigated because they found that the allegations of being shoved in.
Do not assume that this court has not read the briefs, the papers, and all the documents on this case simply because we don't agree with you.
I understand her. All I'm saying is that we're on a motion to dismiss. The complaint is not accurate, and I'm just asking the court to consider the legal principles.
Right, but you started by saying that as a pleadings motion, we are to perceive all of the allegations as true, correct?
Absolutely.
So you can continue to say that they're not true. That is meaningless for the purposes of this analysis.
Agreed, but Your Honor has made a very substantial point that you think that the conduct of the school was wrongful, and I'm just telling you that the allegations in the complaint are not true.
Yeah, look, you know, all of us as parents, you send your children to school and you hope that administrators treat all children fairly and that you don't single out a 15-year-old and have, there were ways to handle this, and this was not it. Okay?
And Your Honor, I think the law says that the discretion on how to handle something like that rests with the school. It's not something that can be second guessed by a court in a legal proceeding. And the Moss case from the Court of Appeals says we give discretion to schools in how to handle things. I think the school handled this appropriately here, particularly on the truthful facts. But I also know that the complaint as alleged doesn't state a claim. They haven't alleged a defamation claim. They haven't alleged a breach of contract claim. And they certainly haven't met the incredibly high standard to show a claim for intentional infliction of emotional distress.
Well, Counselor, there's some material that you've asked to have stricken, I believe, correct?
Yes, Your Honor.
Yeah, and of course we looked at that material, and it's very disturbing material. What disciplinary or actions or other proceedings were taken with respect to the students who created those images?
Yeah, Your Honor, the complaint alleges upon information and belief that no action was taken. I'm not at liberty to talk about how we disciplined other students, but I can tell you that the allegation in the complaint is not well-founded.
That's not your allegation.
The allegation.
Which allegation is not well-founded?
The allegation upon information and belief that the school took no action with respect to these posts. He would have no way of knowing that. And Your Honor,
what was the student? I'm curious. Was the student who was offended by the post of this child? Did that student also complain about the outrageous memes from Lady Meme, which by far, I mean, DP's comments pale in comparison to the outrage on those Lady Meme comments?
I don't know the answer to that.
They don't even compare. Apples and oranges.
Your Honor, I'm not here to defend the post of the Lady Memers. I also am not here to say they have no relevance to any allegation in the complaint. And I think the plaintiffs included them for the sole purpose of embarrassing those students and embarrassing Spence. And I think that was highly inappropriate. And if we're talking about protecting 10th graders and 15-year-olds, I don't think that was in the best interest of the 15-year-olds too. And I can say that as a parent also. Your Honor, unless there's any further questions, I would rest on our briefs.
Any other questions to my colleagues? No. Okay, thank you, sir. Mr. Oliveri, you have 2 minutes.
Thank you, Your Honor. I don't want to belabor the points. Plaintiffs here, we're at the motion to dismiss stage, pleaded more than sufficient facts to support each of its causes of action. If Spence wants to take issue with the allegations, certainly the right to do so, but that's after discovery and not at the pleadings. On the pleadings, the issues have to be decided on the basis of the complaint because there isn't a fully developed record. With that, unless Your Honors have questions, I address.
Thank you so much. Okay, and last but not least is Wormwood Capital versus Mullity. Mr. Himes, you have 4 minutes, sir.
Yes, thank you, Your Honor. Scott Himes for the appellants, plaintiffs below. Your Honor, I know the hour is late. I'd like to take my time to focus on one critical issue in the forum nonconvenience dismissal here that obviously resulted in depriving my clients of a New York forum, and that is, Your Honors, that is the determination that Switzerland is a preferable forum here because supposedly our complaint is about conduct that occurred at the board level in Switzerland. And that is decidedly not so. And that is not what our complaint alleges. And I also think that if I can, in a minute, I'd like to bring the court sort of current on this related federal case, because in our view, Your Honor, you can't square a forum non-dismissal with the recent federal decision that came down literally, as I was writing my reply brief that day against Martin Shkreli, who is, by all accounts, he is a serial he is a serial financial corporate wrongdoer. But my complaint, Your Honor, very much focuses on the wrongdoing by the individual defendants as corporate officers of Dhcr, which is the wholly owned subsidiary of the Swiss parent, Finexis. Finexis does no business, and that's admitted. It's a corporate shell. All of its business is done through its operating entity, Dhcr, which is a New York corporation. I'm sorry, its headquarters is in New York, located at 600 3rd Avenue. And most of the individual officers, 3 of the 4 who were named as defendants here, are New Yorkers. This is a complaint that focuses on wrongdoing by New York corporate officers through the operating entity of the Swiss corporation.
Let's try to cut to the chase, as my colleague, Mr. Judge Schulman, would say. Most of the documents here that are truly at issue in terms of the nuts and bolts of this case are documents that are in the New York offices, aren't they?
Oh, I believe so, Your Honor. I mean,
Right.
we certainly,
So that's
the evidence
really
is
the
here.
the only evidence and documents that they claim would have to be brought in from Switzerland are board meetings and board meeting minutes, basically.
If those don't exist in New York, which I have to believe they exist in New York, the financial records, I'm sure, are
But
in
even
New
if
York.
they don't exist in New York, the record does indicate that these records, while the hard copies are in Switzerland, they are also available digitally. And last I knew, you can send an email from Switzerland to New York in less than a second flat, right? So that again is not a reason to change a otherwise properly venued action.
Absolutely,
Correct?
Your Honor. There's no location of evidence issue here. And if I may, I'd like to just emphasize and explain to the court the recent federal court decision, which, as I say, I don't think you can square the forum non-dismissal with the result of that case. Now, granted, that occurred after the lower court's decision, so Justice Cohn did not have the benefit of that decision. But in the federal court action brought against by the federal government and a half dozen states, the federal government sued Finexis, the parent, Dhcr, the subsidiary, Mr. Shkreli, and one of the individual defendants here, Mr. Mulady. The corporations and Mr. Mulady settled on the eve of trial. Only Mr. Shkreli went to trial. Justice Cote in the federal district court issued a lengthy opinion on January 14th, literally as I was about to file my reply brief. And what she finds there, she finds liability. Mr. Shkreli's liable for $64 million. He is banned from life from participating in the pharma industry. But all of that occurred, number one, through Dhcr, through the operating entity, and it occurred, I'll put it this way, in cahoots with the individual defendants who I've sued in this case. And some of the findings are remarkable, if I may, Your Honors.
Counsel, you had 4 minutes. We're already 3 minutes over.
Okay, so I would.
You will have a minute on rebuttal. All right.
What I would urge, Your Honor.
Have a minute on rebuttal. Mr. Herman, I will hear you. You have 4 minutes.
Thank you, Your Honor, and may it please the court. This is a derivative case against a Swiss corporation. The plaintiffs here bought shares in a Swiss corporation, not in a New York subsidiary. The claims are governed by Swiss law. There is no doubt about that. Counsel conceded it below. After a careful analysis of the forum non-factors, including looking at evidence from Swiss law experts, the court concluded that it was proper to hear this case in Switzerland, and this court has repeatedly held that such determination should not be disturbed unless the court improvidently exercised its discretion or failed to consider the relevant factors. And that didn't happen here. The court considered the factors. There's no abuse of discretion, and the decision should be affirmed. Keep in mind, the court focused first and foremost on the fact that this is a Swiss company and that there would be a heavy burden in interpreting Swiss civil code in these facts. Keep in mind, Switzerland is—
What's so heavy about that burden? We entertain cases from all over the world and deal with law from all over the world. There's nothing so unique about Swiss law that it would create a problem for our New York State judges.
Well, I agree that our New York judges are very talented. This is a this is not.
I wasn't fishing, but go ahead. I'll take it.
Your Honor, this is not a common law country. It is a code country. The law is in German, French, and Italian. And every court that has ever looked at this issue in the derivative contest has kicked the cases back to Switzerland. I understand that our courts will sometimes be called upon to interpret contracts under foreign law, but I challenge Mr. Himes below to find a single case where we are entertaining derivative claims. What you're basically asking the New York court to do is to reach inside a Swiss corporate boardroom and apply Swiss corporate law. And it is clear that the Swiss are much better positioned to do that than we are. They understand the issues, and what would happen here is you'd basically be setting up a battle of the experts on Swiss law, and then not only would you be requiring the judge to—
Counsel, but how is that different from almost 95% of the cases that are tried in this state? Oftentimes, we are left with the battle of the experts, and we are more than adept to do that as well.
Because
I mean, I think here your problem is that outside of board meetings, that really is the only interaction with the Swiss board on the facts underlying this case. Is that not true? A lot of this was done in New York?
No, that's not true at all. That's not true at all. The allegations are that let's focus on what the allegations are. The allegations are that this company entered into what are called VIEs, the special purpose vehicle contracts. If you look at the record appendix, there's an affidavit from Lucas Dhcr in there who said that the votes on those took place at board meetings in Switzerland, not in New York, in Switzerland. That's where the company holds its records. Plaintiffs also complain that the board members entrenched themselves through votes of the shareholders. Those votes took place in Switzerland. Plaintiffs also are trying to evade votes by the shareholders that discharge the shareholders under Swiss law. I'm sorry, that discharge the directors under Swiss law. Those votes took place in Switzerland. Counsel talks about this being, oh, it's all about Viera and the officers of Viera. One of the defendants here isn't even an officer, was never an officer of Viera. How could it possibly be that the claims against him are in his capacity as an officer of Viera when he's not that? If you look at the complaint, Your Honor, it mentions the word director 43 times, 43 instances. These individuals are being sued in their capacity as directors, and that goes to Swiss law fiduciary duties. And if you look at this court's decision, which I think is very instructive, in Hart versus General Motors, that was a derivative case against the Delaware company. And the court analyzed the issues in that case and tried to balance whether it should do the—
This is Judge Gonzalez, if I may. Did you plead any prejudice anywhere? Any prejudice to the individual people who were directors, to any of the defendants here?
Do you mean by prejudice in terms of having to entertain the case here?
Yes.
Is that what your question? I think the prejudice is that they signed up to be directors of a Swiss.
No. Did you respond in any way? Did you say anything anywhere that there's going to be prejudice because they have to travel, I don't know, cross Manhattan or something?
There is one of the defendants has moved to dismiss for lack of jurisdiction. He's based in California. He is not a New Yorker. He doesn't spend time in New York. He's never been to New York for any company meetings. So he has moved to dismiss for lack of jurisdiction against him. And I would submit that coming to New York would raise those same issues. But this
And
isn't a
if-
question
and
of,
if I may, and Milady,
But traveling to Switzerland isn't?
but Your Honor, that you're talking about the burden to them. It's their decision as to whether, and they believe the case should be entertained there. It is, there's no burden to the plaintiffs here. Keep in mind, this is a derivative case. The plaintiff, the real party in interest, is the company. It's not the plaintiffs who have brought this case. And by the way, the plaintiffs who Mr. Himes represents, who have instigated this case, one of them's in Switzerland, one of them's in the Cayman Islands, and then the other two were in New York. It's not as though that these are all New Yorkers. These are sophisticated entities that have invested in a Swiss corporation. And in terms of prejudice to the defendants signed up to be directors of a Swiss corporation governed by Swiss law, and that their fiduciary duties would be governed by Swiss law. And it is only fair to them that their responsibility be determined by a court schooled in Swiss law. And what we submit here, thank you, Your Honor.
You can finish your, I don't mean to cut you off in your sentence. Finish your thought.
The point is, there is no doubt that Switzerland is an available forum. There is no doubt that the court is being called upon to entertain very complicated questions, that there will be a battle of experts here, and that you're imposing a burden not just on the New York judges, but on a New York jury to basically hear a Swiss law dispute. And I would submit, if you look at Hart versus General Motors, and you think about the policy behind this, you're talking about the
All right,
internal.
counsel, I told you to finish your thought. You are now expounding on the thoughts. I thank you, and we have your briefs. Mr. Himes, you have 1 minute.
Very briefly, Your Honor, Justice Gonzalez, you're right. 3 of the 4 individual defendants are New Yorkers. They're telling the court, gee, it's more convenient for them to litigate in Switzerland. Go figure, Your Honors. Most importantly, we hear about board decisions. The record is 100% clear. This was a board that was dominated, controlled by Martin Shkreli. So what Shkreli wants, Shkreli gets. And these individual defendants were his cronies that he installed on the board. He had the voting power, and they're there because he was there, and they were there to do his bidding. Importantly, Your Honors, very importantly, we don't need, and I've made this point in my reply brief, one of the issues was equitable relief that was directed at the Swiss company. Off the table. Everything has changed since I filed the complaint. New board, Shkreli is enjoined from voting his shares. So I just want that thought to be there as well. My last sentence, Your Honors, is yes, my clients invested in a Swiss company, but they sure didn't plan on investing in a Swiss company that was going to use a New York subsidiary to commit wrongdoing and to enrich individual defendants themselves.
Thank you so much. This ends the session of the Appellate Court First Department for today's calendar. I bid you all a good night.
Thank you.
Thank you, Your Honors.
Thank you.